Hello, my name is Nathan Chapman. I'm an associate professor of law here at the University of Georgia. And my guest today is Professor Thomas Gallanis, who is Associate Dean for Research and the Alan D. Vestal Chair in Law and Professor of History at the University of Iowa. I'm delighted to have Tom here today to discuss his current project about the dark side of codifying the law of trusts. Thank you for being with us, Tom. I'm really glad to have you here.
It's a pleasure. I'm here this week at the University of Georgia as the visiting Verner F. Chapman Chair in Law, and it's a particular pleasure to be at Georgia because this law school has such a long tradition of excellence in the field of trusts and estates with Richard Wellman, Verner Chapman, and so to be here holding the Verner Chapman Chair on a visiting basis is a wonderful honor, and I'm having such a good time.
Oh, I'm so glad that you have been here. It's been our privilege, and I'm really excited to hear about your current project. So you've been involved in the codification movement to some extent regarding trust. Can you tell me a little bit about your experience with that?
Sure. The Uniform Law Commission prepares uniform acts in a variety of fields of law, but the Uniform Law Commission has been particularly active in the field of trusts and estates. This goes all the way back to the Uniform Probate Code, for example, which was originally promulgated in 1969, and it was Richard Wellman who was the chief reporter for the Uniform Probate Code. Since then, the Uniform Law Commission has promulgated dozens of acts in the trust and estates field, including the Uniform Trust Code, which is the first really comprehensive codification of the law of trusts in the U.S.
Wonderful. And the occasion for your paper, as I take it, is the 20th anniversary of that code. And one of the things that you were kind of keen to examine, maybe a little bit impishly, is the dark side of embracing the code or codifying the code. What is the dark side?
Sure. So, as I said, the Uniform Trust Code was promulgated in the year 2000 by the Uniform Law Commission. So we're approaching its 20th anniversary. And the American College of Trust and Estate Counsel publishes a law review called the ACTEC Law Journal. And the editor of the ACTEC Law Journal thought that the 20th anniversary of the UTC would be a good opportunity to look back and to examine the UTC over these 20 years. My sense was that the symposium issue is designed to be largely celebratory. Mm-hmm. And perhaps it is my inclination to swim in the opposite direction, but I thought this might be an interesting opportunity to explore whether there have been any downsides to codifying the law of trusts. As I started to think about the project from that perspective, I realized that turning trust law from common law into statute law created an opportunity for interest group capture. And here I should say a word about the uniform law process. Mm-hmm. The Uniform Law Commission is composed of commissioners from each state, appointed by the governor of each state. And they are law professors, lawyers, judges, and they work to prepare model legislation, which can then be enacted by the individual state legislatures. Once the Uniform Law Commission finishes a product, it does go to the state legislatures for them to consider. The legislatures can adopt the act verbatim, but that's rare. Often there are modifications that are made before enactment. In each state, there's a process of study of a uniform act where constituencies within the state examine the uniform law product and decide whether it's appropriate for that state, decide whether to make any modifications to it. And it's during that process of study within the individual potentially enacting state that various interest groups can come in and change the uniform text. So, just to give one example,
Mhm.
the Uniform Trust Code provides that the trustee has a mandatory duty to provide information about the trust and its administration to at least some of the trust's beneficiaries. And this is not an innovation, this is a long-standing principle of trust law. However, some jurisdictions have decided to eliminate this as a mandatory rule and instead allow the creator of the trust, called the settlor, to provide in the trust instrument that the trustee has no obligation to provide any information about the trust to the trust's beneficiaries. Of course, this causes a problem in trust enforcement because it is the beneficiaries who are the equitable owners of the property and trust, and we typically think of the beneficiaries as the ones who monitor and enforce the trustee's fiduciary obligations. Changing the duty to provide information from a mandatory rule to a default rule that can be completely eliminated by the settlor of the trust would have been very hard to accomplish when the law of trust was case law. But in the legislative process, with the stroke of a pen, a state legislature can decide to eliminate that as a mandatory duty. It's not typically the legislators themselves who are making this move. It's the various interest groups, particularly bar associations, associations of bankers and trust officers, who want to provide a framework of trust law that they think will enhance trust business in that jurisdiction to make it more settlor friendly. And so it's kind of it's an interesting story of interest group capture as the law turns from common law into statute law.
Got it. So at the retail level, which is the way that common law develops, there probably would not have been any occasion for a judge or a party to really push persuasively for a change in this longstanding rule. Whereas when the legislature sort of looks at a wholesale change to the entire body of trust law, it gives an opportunity for interest groups to influence around the margin some of these rules that have long lived as part of the common law of trust. Is that more or less a way to put it?
That's exactly right. So this symposium issue, the the contributions were supposed to be very short, only 2,000 words, including footnotes.
Mm-hmm.
So this was my first foray into this idea of the move from common law to statute law as providing an opportunity for interest group capture. Now I am just embarking on a project that tries to look at this more in depth. The idea is that it will become a full law review length article, but I'm at the very early stages of this project, so I'm thinking through the phenomenon that I've observed, thinking through it both practically and theoretically, and trying to think about it more deeply than I could in a piece that's only 2,000 words.
Yeah, it's a really interesting story of legal change. A couple questions. So the project seems to presume that you've got interest group capture at the codification stage. What are the risks of interest group capture at the stage of the unifying process? So the process in which the organization has developed the uniform code.
That's certainly a risk. However, the Uniform Law Commission has a strong published norm, which is adhered to in practice, that the commissioners leave client interests at the door. And so, as I have been gathering examples of changes in the law of trust that I think are reflective of this interest group capture, so far all of the examples that I've been able to find are examples where the change in the law happens after the promulgation of the Uniform Act. It happens at the level of the individual state legislature. One way to
So I would want to follow up on that really
Sure.
quickly. So in other words, in those cases, the proposed uniform rule was the old common law rule. The uniform committee didn't propose a sort of reform to the common law rule. It was just stating the traditional rule. Is that correct?
Well, I guess I want to modify that a little bit because often the uniform law is coordinated with another organization that has a role in stating and modernizing the law, and that's the American Law Institute, which produces the restatements of the law. The restatements third, and we're now on the restatement, we recently published the restatement third of trust, the restatement third of property. The restatements third have a mixture of simply stating what the law is and moving the law forward where it seems advisable to do so. But in order to have a rule become part of a restatement, the membership of the American Law Institute and the Council of the American Law Institute have to be on board. Those groups are composed not just of academics, but also of lawyers and judges. So the idea is that this statement of the law has broad support within the various sectors of the legal profession. There are parts of restatement law and uniform law that are a little more reformist than simply codifying or restating the old common law, but they do so in a way that has broad assent within these organizations. So you may well find a restatement rule that then becomes part of the Uniform Act. But again, that's because the commissioners of the Uniform Law Commission, who are judges, lawyers, law professors, all are on board with this rule.
Do the lawyers who participate in the Uniform Law Commission, do they represent a variety of client groups? So some sort of more on the sort of wealthy trust side, and others on the beneficiary side, or does the organization screen for potential interest group capture there that you might see even at the legislative level?
Sure. There are hundreds of commissioners because they're appointed from all the states, and the states have a varying number of commissioners. In my home state of Iowa, we have 3 commissioners appointed. Some states have more commissioners. The commissioners vote by state, so it in the end doesn't make a difference how many commissioners there are, but this is quite a large organization. The commissioners are appointed by the governor of each state, and they represent the broad spectrum of the legal profession, although we are talking about accomplished and senior members of the legal profession. But there are people who specialize in litigation, in corporate practice, in trust and estates practice, in family law practice, really across the board of the legal profession. The same thing with the judges who are members of the Uniform Law Commission. Some are probate judges, some are family court judges, some are civil court judges, some are state Supreme Court judges. It's really across the board.
Got it. So this is fascinating. And I wonder if you've considered the flip side of the change in the states that sort of take this opportunity to allow some capture to tweak, as it were, the proposed uniform rules. What about the states that don't tweak it? All right, does that reflect no interest group capture, or perhaps capture by another group? Would there be a way to test for that?
That's a really interesting idea, and this is why I've been so grateful to have the opportunity to present this very preliminary project here at a faculty colloquium at the University of Georgia Law School, because that suggestion was made to me, and it's a very good one, to think not only about what happens when a uniform law is changed at the enactment level, but why is it when a uniform act is adopted without change? What are the reasons for that? And could that be a story of capture in a different way? I think that's an excellent idea, and I'm very grateful for it. This project is at a very early stage, so I'm glad to have ideas like that I can explore.
Sure. So One last question, perhaps. I know it's early in the project, but I wonder if you have a hypothesis about ways that groups like the Uniform Commission could try to reduce the risk of capture uh, that in the kinds of capture that you're describing that often kind of skew the proposed rules in favor of one group in society over another.
I think this is going to be part of my project, but here are some preliminary thoughts.
Hmm.
I do think that the Uniform Law Commission could do a better job of explaining the rationale for the rules that it adopts. Um, every Uniform Act has the statutory text of a section and then an explanatory comment. Sometimes those comments, though, are briefer than they could be. Um, Ultimately, the choice of how to enact a uniform law is left to the individual state legislature. But I do think that if the Uniform Law Commission spelled out more the policies, pro and con, the factors that the drafting committee weighed, the reasons why it came down on the side of a particular rule rather than another, the reason why a particular rule is better than another, the factors that might not be obvious just in reading the statutory text, that may go some distance in helping to persuade that the uniform law rule is the thoughtful rule. Alternatively, if the Uniform Law Commission can't explain its rule in this kind of detailed way,
Hmm.
then perhaps that's an indication that the rule should be different. But I do think, by and large, the rules are very thoughtful. It's just a lot of that thought gets expressed during the drafting process. So
Hmm.
the people in the room know the considerations that went into the final product. But sometimes, but not always, those considerations are not reflected in the final draft.
Right. And you suspect that legislators who are trying to operate in good faith, but basically outsource the evaluation of the details of these codes to a portion of the bar who are experts in this, that more information, which just footnote, this may be one of the first times we've talked about a group of hundreds of lawyers getting together and producing too brief a product. But um, back above the line, um, that what you're doing is kind of giving lawmakers more tools to analyze the proposals that their bar members are giving to them.
Yes, and not just the lawmakers, but what happens after a uniform act is promulgated is that it goes to the individual states for them to consider. Often that consideration begins in committees or sections of the State Bar Association. And so those lawyers will be studying the uniform law product. And I think if the Uniform Law Commission could do a better, more thorough job of explaining the rationales behind the uniform rules, that might go some distance. Also, I think it's important to recognize that some of this is shaped by the fact that the Uniform Law Commission itself has interests.
Hmm.
It is in the Uniform Law Commission's interest to count as many states as enacting states as possible so that the
Hmm.
Uniform Law Commission shows that its products are successful. Sometimes what that means is that the Uniform Law Commission doesn't push as hard as it might for the uniform rule. The Uniform Law Commission essentially folds its cards
Hmm.
on a particular issue so that it can get the majority of an act enacted and thereby count that jurisdiction as an enacting jurisdiction. Perhaps if the Uniform Law Commission did more to make the case
Hmm.
for its uniform rule, it could be persuasive. I don't know. We're at the very early stages of the project, and I don't want to commit myself
Sure.
to any one of these views. I think this is a fascinating project that I'm embarking on, but it's at the very early stages.
Yeah, I agree. It's very interesting as even as a case study in the way that uniform commissions relate to legislatures. It has tons of implications well outside the field of trusts, even though the implications here are quite intriguing. Um, Thank you very much for your time, Tom. I think that's all the time we have for today, but it's been a delight to have you here, and um, good luck on the rest of the project.
Thank you. It's been a pleasure.